Ready, Ms. Weaver?
Yes.
Let's get started. Hello, Ms. Lyons. Who is going to be the primary spokesperson for the state? Mr. Abate. Me. Nice smile. Okay, Mr. Abate. And Mr. Samuel? No. Okay, for the defense. We're going to work through this however you want. Because you've had the charge long enough, my thought was, rather than going through your submissions to say, here's where this is and here's where that is, that we simply go through the draft charge, and I'm going to jump to the areas where I have questions. And if I jump over an area where you have a question, concern, objection, then you should say, wait, let's go back to page X. But I'll tell you that my first question relates to the charge that begins on the bottom of page 5 and carries over to 6, limited consideration of other wrongs. I don't know if that was because there was maybe going to be 404B, or I don't know what's behind it, but that's a page worth of instruction. I guess I should preface all this by letting you both know my philosophy is the more concise we can be for the jurors, and the more we can craft these instructions so that a lay person can understand them, the better. I don't think we need the charge relating to limited consideration of other wrongs. Mr. Abate?
State agreement. I am actually in agreement also, but I want to make sure Mr. Driver understands that. But
Sure.
I'm in agreement that you should not give a 404B charge at this point. You
Okay.
gave one mid-trial if we thought there was a necessary. Check this out.
Please stay seated, and if you're out, you can take your jacket out now. Doesn't bother me.
If, because we didn't do one mid-trial, that's a pretty good signal that we didn't, in fact, do it as being 404B, other than we did move to exclude it.
Sure.
But it just didn't need an instruction. In our view, it kind of emphasized that it's tentatively, we vote to keep it out, but I would like to get a final vote taken from my client.
Okay, I'm going to strike through it in my draft here, and tentatively it's out.
Did you want us to interrupt you if you skipped over something already?
Why don't we go back to what you have a concern now that we've addressed the 404B/limited consideration of other wrongs charge, and it's tentatively out. Let's move back to where you want to start.
I know this is going to sound a little bizarre, but I'm on the defendant's choice not to testify on page 4.
Yes.
That is the pattern charge. Your vote to keep things concise and to make things understandable and not necessarily consistent desire. And I don't know if you ever listened to Mr. Rankin's breakdown, but this concrete case that he reported about discussed how the jury deliberated, and they understood this charge very well, and they knew that they were not allowed to consider it, but they sure as hell were allowed to discuss it. And that's what they did. The jury reported back to the press later. They spent a lot of time talking about the fact that the defendant didn't testify. They just knew that they couldn't consider it in their verdict. So I'm going to ask you to add a clause that says, when, as here, the defendant chooses not to testify, you may not consider that decision or even discuss this matter in any way in reaching your verdict. They can't discuss it. It's an absolutely true statement. They're all sitting over there shaking their heads as if it's perfectly okay to talk about it.
Hypothetical. Well, you know, the defendant, I'm now a juror deliberating. The defendant said X, Y, or Z. Oh, you know, the defendant didn't testify. No, I'm not saying he testified, but according to Dan Joe Carter, he said X. Is that a violation? Is that considering his testimony?
I completely lost that. It's the exact same concept as what's in here. Not only can you not consider it, you can't discuss the fact that he did not testify. I can't understand why your hypothetical is any different than what's already there. It just adds to the word consider.
I understand what your request is. I'm just trying to understand.
Of course they can discuss the fact of what Mr. McIver said to David Judge. Of course they can. They just can't discuss the fact that he didn't testify.
Okay. Mr. Abate, your thoughts on that?
I would disagree. I think the charge is appropriate as it's written. The pattern charge is appropriate as it's written.
Well, why not be more specific with the jury that by consider, that also means discuss?
Because I think it adds unnecessary or additional language that is not necessary. I think it's clear as it's written, and I think by adding the language that Mr. Samuels is asking the court to add actually create some confusion, as Your Honor has kind of pointed out through the discussion we had with Mr. Samuels.
Well, according to the podcast, I think this is the trial where the editor of the AJC was a juror. And there was a particularly good segment of the podcast about jury questions.
Pretty guys out.
Yeah, I commend that to all the doubters. Jurors talk about it, apparently. Should they? Because if they shouldn't, then why not add consider includes discussing?
Well, all I would say to the court in response is that was that jury, this jury, and they have followed every instruction, as we know, that Your Honor has given, so I don't see why they wouldn't follow the instruction as the pattern, as a bunch of judges have created the patterns, have written it.
Okay.
That's my response. So.
All right. I'm going to add or discuss. Next.
We are now beyond the 10th of the stage and agree with eliminating the 404 instruction. That's no longer 10.
Okay. It is now not even struck through. It is gone. Okay. Oh, except I'm going to leave it in right now. I will, because my pagination will get messed up before getting you to where we're talking on the same page. But it will be removed. Okay. Did you have anything else prior to the 404B instruction? Okay. The next one I had is on page 7, dates in the indictment. I haven't heard there being lots of confusion about things, and it may have related to count 6 or 7, but those are both gone. Does the state still want the charge about dates aren't material unless they're alleged to be material as long as it's within the statute of limitations? September 25th is pretty locked in.
I think in light of Your Honor's decision as to count 6 and 7, I don't think it's necessary.
Okay. Mr. Samuel?
Agreed.
All right, that is going to come out as well. The next thing I have is page 11 to 12, contributing to the death of another. Was that jumping past?
Oh, yeah.
Okay, let's go to whatever comes after dates in the indictment from the defense side.
The next instruction is peculiarly inapt.
Accident?
In this case. It's because of the use of the term criminal negligence in the accident instruction and how confusing that is, because it would lead a jury to believe that if there was criminal negligence, you can find them guilty of murder. What this instruction does, because of the placement of it, first of all, I think the accident instruction ought to be after the murder instruction. But even wherever it is, accident is a defense to malice murder. It arguably is a defense to felony murder.
And aggravated assault.
Yeah. But not if it's just criminal negligence. It's not, you're saying it's not a defense if the offense was committed through criminal negligence. If the offense was committed through criminal negligence, you're not guilty of malice murder, then you're down to involuntary manslaughter misdemeanor. So nobody could read this instruction and understand the relationship between criminal negligence and counts 1 through 4. So somehow this needs to be crafted in a way that accident follows malice murder, leave out the criminal negligence from this part of it. If it's an accident, and if the burden of proof correctly, then it's none of the four crimes.
That part I agree. If it's an accident, then the jury must find Mr. McIver not guilty of,
Period. Or not guilty of all four counts. If there's no criminal scheme or intention, he's not guilty of counts 1 through 4. If he's only guilty of criminal negligence, that is a misdemeanor involuntary manslaughter definition. Criminal negligence is not a substitute for malice. So at that point, you've got to say, if you find only criminal negligence,
we get your proposed charge 3 or something to that effect.
and you're still not guilty of malice murder, or aggravated assault, or possession of a gun by a convicted, possession of a gun during the commission of a crime. So it's, somehow you've got to get the criminal negligence out of the accident and into the lesser included offense.
So, okay. I think this is the pattern charge. It doesn't mean we're locked into it, but the way you phrase this is that I spent some time coming up with this cockamamie accident charge.
No, I understand.
Okay.
I'm not blaming you.
No, I'm not feeling blamed, but I also, this is how it normally comes on out. But you're saying, given the way this case is, we may need to deconstruct it and move some parts around.
That's right. I mean, perhaps I don't know if this expression is ever be appropriate in a malice murder case. Can criminal negligence ever be a substitute for malice if it's in fact involuntary manslaughter? That's all it is. But it's certainly not in our case.
How, I'm not disagreeing with maybe the need to parse this out. So I guess reckless conduct is almost like gross criminal negligence. It is
That's right.
negligence prime, and that's why that makes it felony involuntary, because it's a misdemeanor. The commission of that misdemeanor would turn things into felony involuntary manslaughter.
Exactly.
Whereas criminal negligence
It's a misdemeanor involuntary.
is for the jury. Okay. Mr. Abate, it sounds like we have 3 tiers short of plain old not guilty, make the 4th tier. That's a pretty bright line. We have 3 tiers of potential culpability. If the jury were to find that Mr. McIver were merely criminally negligent for holding a loaded gun pointed at his wife's back in a car, then we'd be talking about misdemeanor involuntary manslaughter. If it is in fact reckless conduct, then it's felony involuntary manslaughter. And then if it was an intentional act, then it's as charged. It does seem like I need to massage the accident charge a little bit so that the jurors don't see a finding of criminal negligence as if it was sort of a flow chart. Criminal negligence leads to malice murder, because it doesn't. You agree with that?
Yes, I do agree with that.
Okay.
And the second paragraph is part of the problem.
The second paragraph being the definition of criminal negligence.
Exactly, which is the same definition we offer, but it's in a completely different context.
When you say a different context, meaning where it's like physically it's context. As your point isn't the language, it's just when you stick it right there,
It's in our request number 3.
Yeah, I see it in 3. Okay, so I need to restructure. So your objection is not to including accident, I trust. And you are acknowledging that if accident is in there, then at least based on the evidence of record, there ought to be what I'm going to call for shorthand, misdemeanor involuntary as a lesser included. We can get to reckless and felony involuntary in a minute, but that misdemeanor involuntary is sort of part and parcel of accident. It won't be in the charge, but it's not the case that the only option for the jury, given these facts, is it's either an accident or an intentional murder.
Exactly.
Okay.
I think your flow chart is right. I haven't quite figured out how to restructure this, and I'm sorry, maybe I should have before now, but I will. I'll post something before Monday morning, but you're right. Somehow this has got to be restructured so the jury understands exactly what you're saying, and it's not necessarily going to be concise.
No. Understandability trumps concision.
Exactly.
I'll say it comes out ahead of concision.
Thank you.
Slime bag liar.
You get $100. Adam's going to pay up.
I didn't respond to the email.
All right. So I will take a swipe at putting accident in a different part of the charge so that there's murder, felony murder, accident, misdemeanor involuntary, and felony involuntary, all in the same little area. And then we'll need to work through that again. But what I'm not hearing is an objection to the inclusion of any of those charges. It's more structuring and delivery. Is that fair?
It's more than fair. It's exactly right.
Okay. Mr. Abate, you agree? As I added sua sponte that felony involuntary and reckless conduct got in there. Neither side asked for that. But that is, I believe, a very reasonable interpretation of the evidence in this case, and it's ought to be included. Does the state have any objection to the inclusion of the felony involuntary manslaughter and reckless conduct?
No, we'll leave it to discretion, Your Honor.
Okay. What else, Mr. Samuel, before we get to contributing to the death of another?
On 10, you didn't define assault, which I think the law requires you to. In an aggravated assault case, you have to explain what an assault is. It's all part of the pattern.
All right. Yeah, no, that's aggravated assault. And it may have been in another case, because I gave to Ms. Lyons some of the charges I had used in other cases that folks were okay with. I don't disagree with you. I'm happy to add that in. I don't know that it's going to be a big issue in this case, but it doesn't mean it shouldn't be in there.
Yeah, it has to be intent element of assault. That's what it means.
Okay. Any objection to adding the definition of assault to the charge on aggravated assault, Mr. Abate?
Now you know.
Okay. It's going to be an interesting verdict for him. All right, now contributing to the death of another? Or is there more before you get there?
Yeah. Well, the lesser included offense, so what you're saying you're going to add the misdemeanor involuntary.
Yes.
We have an instruction, we call it theory of defense instruction, with involuntary as well, it kind of explains it, but I don't know, there's no pattern on misdemeanor involuntary.
Okay.
So I already know that the instruction I suggested, number 3, was we just kind of took a statute and broke it down and tried to make sure it was all there, but I think we found that there was no pattern, and for some reason. So
I will.
I want you to think that I quoted a pattern there, right?
No, you in fact cited about 6 cases and a couple statutes.
Yeah.
Usually when I see a string cite like that, it means someone is.
Okay.
Yeah. So I will be incorporating at least some of the concepts from your request to charge 3, because the jury needs to be instructed first in the concept of a lesser included offense, and then this is where the criminal negligence piece would go. What criminal negligence is, and misdemeanor involuntary manslaughter, which is much of what you set forth in your request to charge 3, and then also felony involuntary manslaughter. Not that I'll call either of them misdemeanor or felony. So, assuming that
I think your lesser included offense instruction is not right.
okay,
And I think what we said in our instruction is right. Of course. But, I mean, I think you quoted the lesser included offense if it's going to be voluntary manslaughter. That's some mitigating circumstance.
okay,
Our instruction correctly says, if you don't reach a verdict on murder, and note it doesn't say if you acquit, it says if you don't reach a verdict, that's the Supreme Court's language on what it takes to justify a lesser. Then you should consider these 2 other charges. I would hesitate to even use the word lesser. I don't think the jury needs to know lesser or greater. They just need to know there's other options. And it's not a mitigating circumstance that leads you to involuntary. Nobody's asking for voluntary in this case. You've got to get from murder to involuntary if you find an absence of intent, not a mitigating circumstance. And once you find an absence of intent, then the question is, was there reckless conduct or was there criminal negligence? And
so accident is not a, well, accident is not, it's just a defense, it's not a mitigating circumstance.
it's not a mitigating circumstance. It's
Okay.
an absence of intent.
I agree, this isn't the right transition to whatever I end up calling them, lesser included, or, look, it's been interesting that you've been thinking about murder or felony murder, but if you don't find that, you also need to consider these other options. Okay.
That's right.
Okay. So my proposal remains that I need to deconstruct the accident charge, relocate it, and walk the jury via this charge through murder, felony, murder, aggravated assault, gun charge, and as well as the notion that there is out there criminal negligence and an involuntary manslaughter connected to that, and reckless conduct and an involuntary manslaughter connected to that. And because you don't have that in front of you right now, I don't expect you to say, well, I think it looks great, Judge, but conceptually it sounds like we're all on the same path. Is that, one second, and this is not on the record. I gave to Elgin the more urgent ones when I had that. So I will get to you all something by Monday morning as well. You're welcome to draft your own, and I'll see how they compare, but I need to take the pen on this as well. Does that work for the state? Mr. Samuel?
Yes.
Okay. Now are we to contributing to the death of another?
Yes.
I don't understand why it's in here.
I don't do.
State?
We'll withdraw.
All right.
With anticipation that there could have been some testimony about the reason this guy was no longer with us because of some malpractice on the part of Emory University. Obviously, the testimony didn't occur, but that was the reason for putting it in.
Great. I don't have any other questions or concerns.
Well,
Mr. Samuel, I'm sure you can make up for that lack on my part.
I'll point out the things you missed. On page 12, next instruction, you can't have possession of a firearm during commission of a felony for misdemeanor involuntary. So you're going to have to, once you add misdemeanor involuntary, you're going to have to tell the jury you've now finished completing your evaluation of 5 different crimes. Only 4 of them would support the firearm charge. Murder, felony murder, ag assault, and felony involuntary. And I have to tell you, we are still doing research on whether the firearm count can tie back into a lesser included as opposed to a charged offense.
All right. Same question. I don't know the answer to that.
Neither do we. It certainly can't get tied into criminal negligence. That's a misdemeanor. It has to be a felony. So We're still trying to find the answer to that question.
Okay.
We started research on it 2 weeks ago, and then got interrupted and moved somewhere else. So we got the answer to that.
I'm sorry someone interrupted you.
Yeah. But for sure, it can't be linked to the misdemeanor, and the jury can't be told one's a felony, one's a misdemeanor. We just tell them.
Right, so what I envision, and this is tentative, and it may all come out if in fact you can't predicate that type of firearm charge on a lesser included. I don't know why that would be if the lesser included is a felony, but you might as well look.
Might as well. And object if there's no law.
Of course, and preserve it, and make new law.
Right.
Murder, felony murder, involuntary manslaughter based, well, but I'm going to tell them that that's a felony. I have
And you don't have to. And you're not supposed to. You're not supposed to tell the jury one crime is a felony and one's a misdemeanor.
I guess I do all the time, but if it's in the context of there are only felonies in the indictment, what's the difference? But here, there's a big difference that they need not know about. I would appreciate that.
That's right.
Okay.
So we'll have to name the involuntary manslaughter options, A and B, or...
Well, I suspect it's going to be along the lines of involuntary manslaughter based on criminal negligence, involuntary manslaughter based on reckless conduct. Because I'm going to be emphasizing, in a bad way, but distinguishing them. Criminal negligence, reckless conduct.
Right.
So, I'm not disagreeing with you, but you are effectively requesting that we play a silly game of hide the ball because, of course, the name of the crime is possession of a firearm during commission of a felony. For the purposes of your deliberations, you may consider these four, I'm not going to include a modifying term, offenses.
That's correct.
Okay. I don't disagree with you, but I'm not going to change the name of the offense. Possession of a firearm during a commission of some kind of crime that we're not going to name.
That's fine.
Okay. All right. I will work through that.
And then influencing a witness. We've had 2.5 hours of arguments, 30 pages of briefs, because it's a complicated statute, and I don't think being concise in one sentence will give the jury a clue.
All right, I'm not there yet. I've heard everything you said, so maybe we'll do 2 sentences, but I'm cleaning up this other thing. Okay, I will work on that, what the felonies are. Okay, influencing witnesses. You want to say something other than the statute?
Well, our request to charge one, obviously dealt with counts 6 and 7 as well.
It was a good story version of a charge. Can I give your closing as to those counts to the jury in my charge?
That would be fine. I think that it is we all recognize it's a confusing statute, and I don't know why we want to leave the jury up in the air. To fully understand what it took us a while to understand, even ourselves, in talking about this. Anybody who reads that one sentence is going to be as clueless as whoever wrote this indictment originally. That was not anybody in this room, I'm sure.
Okay, I don't agree 100%. You have been particularly effective in your briefing and arguing about the directed verdicts. We said, just read what the statute says, which is largely what is included in this one sentence. But if you have language you'd like to include other than the closing argument you drafted in charge number 1, then I'm happy to think about more, but that paragraph isn't what I had in mind when I get frustrated with some of these pattern charges and the abandoned and malignant heart and stuff like that. I mean, if you want to spend some time or point me to individual phrases from your multi-page, somehow simpler and more accessible definition of influencing witnesses, I'm happy to look at that.
The first thing I do is I get rid of the term influencing witnesses. That is the title of the statute that has 6 different options, only one of which applies. So let's just call it misleading witnesses. That's what the crime is.
Okay.
And he's, but the title, because the authors of the Lexis version decided to give it a title, misleads the jury.
I don't want to mislead the jury.
Isn't mislead the way to influence the witness?
I'm just letting them make the record. I don't know that I'm going to change the name of it, but I'm more focused on the words that follow the title.
Well, I think the title misleads.
Okay.
And I think the title ought to say misleading a witness.
Okay.
And then, you say it's argumentative, but there's plenty of charges that define things by showing what it doesn't include. And that's what my request number 1 sought to accomplish, which was to, here's what misleading a witness means, but let me caution you, it doesn't mean something else. It's not argumentative, it's not saying those other things do or do not exist. We often define things by excluding things that are not encompassed within the definition.
Okay.
And if it's too argumentative, I'll modify it or tone it down, but
It's usually, it's not always, but it's usually a clue that if you have to say in a jury charge, in other words, we're running into some, gosh, this isn't really clear, because then you have to restate it in a different way.
But, part of it is caused by the problem that this instruction was written for count 6 and 7 as well, so it focused a lot on the newspaper count. And kind of, the bringing in the non-part count. So obviously I can do a better job with this now if it's just going to be count 5. But I think we ought to tell the jury exactly what we were talking about even this morning, which is simply telling somebody to lie is not in and of itself a crime.
Agreed.
Okay. It has to be.
Oh, wait, I don't know that I agree. Simply telling them to lie to law enforcement or a DA's office or a judge, you are getting closer to the line. Simply saying, hey, just go to the media and lie, that's...
No, I'm talking about simply telling someone to lie to the police is not a crime, unless you were misleading that person.
That it was okay to lie to the police.
Such as.
Okay.
I'm okay with that. I mean, listen, I think you seriously need to figure out whether you're going to agree that they can do that in this case where they didn't charge you, but that's a different issue.
Okay.
I think for some reason they're allowed to argue facts that are not in the indictment. Yes, that's what you have said in the instruction.
Okay. Do you guys have a perspective state on what the influencing witnesses charge ought to say?
I think it's completely appropriate how Your Honor has it in your draft charge. I think what Mr. Samuels is arguing is something you argue in closing, not something that the judge should be instructing the jury on, because it's not, what he's saying is not the law. It's not what the statute says. It may be what Mr. Samuels' I guess interpretation of the law is. Again, that's for closing, not for the judge to instruct during instruction.
Okay. Well, I think it's a mix. That's just why I'm pushing back with him a little bit. I think much of what's in there is the law. It is repeating it in different ways and parsing it out, and I'm okay parsing it out. I wish, and I'm just not on the committee yet, that the Superior Court and ultimately the Supreme Court would get down to breaking offenses into elements like you have at the federal level. So it would say, these are the elements of the crime, which is what jurors crave, as opposed to 3 dense paragraphs of Middle English. And this breaks it down into some elements, but it weaves into there, I think, a little bit of what you're describing, I think, fairly as closing argument. Here's what I've done. I have made a note with a question mark whether I should expand on the influencing witnesses instruction that's in there. I think it is sufficient. It certainly tracks the statute. I don't think it's confusing. I don't think there's a problem with the title. I appreciate that the defense disagrees and has objected and accepted and made a record of that, and I will take that under advisement. What, after influencing, there are not many pages left, what else? That's it. Steve, you've been very quiet. I haven't been ignoring you, but have you any spots in the proposed charge that gave you pause or concern?
I think get all high points.
Okay. Well, let me recap so I know what I need to work on. I'm sorry, did I speak over you?
No, it's true. Harvey said Angela points that, I agree with that as well.
Okay. I'm taking out limited consideration of other wrongs. I'll take out the dates in the indictment charge. I need to add a definition of assault, meaning aggravated assault. Some pretty serious work with lesser included offenses and correspondingly a verdict form, a draft of which I'll get to you all soon enough, not today. Removing contributing to the death of another. Massaging a little bit the second to last sentence, also the second sentence, in possession of a firearm instruction so that we're not labeling things like felony murder a felony. Influencing witnesses, I may expand a little bit. I think that's it. And to be clear, I said it before, but it bears repeating, as I'm thinking about how to restructure all the lesser includeds, I may well pull from defense request to charge 3 for both language and structure, but all that part needs to be rebuilt a little bit. Anything else from the state that we ought to discuss before we break for the week?
I don't think so, other than for the influencing witness charge. When you're saying you're going to, I guess, possibly add language, are we talking about from the defense's request to charge number 2 in the original one that they sent?
I think it would be number 1, but it wouldn't so much be saying, I like that sentence. I just will read through it, and if I feel like there is something in there that helps better explain what the offense is all about, I might include more in what I think is both concise and accurate that's already in the charge.
Okay, I was just curious because the defense request to charge number 2 underneath 1 also deals with the same 5 and 7, and that one it says in the defendant's theory of the defense is that he did not intend to mislead. I don't think
right. I have not ever, and doesn't look like I will this time, have a charge about the defense theory. It's like I'm not interested in sharing with the jury what the state's theory is.
And I assume that I was making sure that that was not where Your Honor was potentially going to be pulling language from charges of influencing witness.
No, sir. Mr. Rucker, anything else? Okay. Anything else from the defense? No, Mr. Rucker. No? No. Okay. If something comes up with plans for the jury that I could help resolve, just shoot an email out to everyone, even if it's over the weekend, because I understand it may involve doing some work over the weekend to try to sort all that out. I'm happy to help. Otherwise, I'll see everyone around 9 a.m. Monday morning. State, you're going to have the few witnesses that you mentioned. Obviously, you're not bound by just those 3, but you heard me tell the jury that closings start Tuesday morning. So you proceed at your own peril. And we'll go from there. Is Ryan anything else? You and I need to talk. We're good. Okay, we can talk. Great. All right. And I received word from Ms. Weaver that she will be able to help us out early next week, which satisfies the jurors' special request that they wrote me, that Ms. Christina finish out, we call it a hearing, as court reporter, world's longest hearing. All right, thank you, everyone. Have a good weekend.
You got the $100 bills